This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
Good evening. My name is Joe Sam Robinson. It's my pleasure to have with us tonight a frequent guest, Professor Buck Melton. Welcome,
Always happy to be here.
Welcome, Buck. Well, we've had lots of conversations about different subjects, and tonight we're going to jump into protected classes, which is an interesting concept. Would you like to define what a protected class is?
Well, the basic definition is pretty much what it sounds like. It's a class or group of some identifiable people who have something identifiable in common that gets some sort of special legal protection, usually in light of discrimination against them in the past in American history, and because of that, they have received special protections under federal law and the Constitution.
Well, let's just talk about that. Well, going back to our situation in Europe, whatever,
Yes.
there were protected classes where maybe the nobility sometimes. There was something called the Wehrgeld, where if you were the lord and, I don't know, someone cut your foot off, you got 100 shekels, and if you were a peasant, you got 2 shekels.
Exactly.
So there were
Yes.
situations in the past where the big dogs got a lot of heads up there.
Yes.
Is that right?
And by the way, it's very interesting that the Wehrgeld was it's sort of the original version of workers' comp, that you can actually quantify the worth of an injury to someone, and from death all the way down to minor problems.
So, if I just to sort of start as a springboard for our discussion about present circumstances,
Yes.
going back to English common law or back to tribal, I guess Anglo-Saxon tribal law, there was the concept of some humans were worth more than others, and they got special
Yes.
privileges. And then, just to continue, I think in the House of Lords, if you were a lord in the UK, then you wouldn't necessarily, you were, I guess, in a capital case, you would be taken before your peers in the House of Lords.
Well, that's where the phrase jury of peers begins,
Yes.
because it originally referred to the peers of the realm.
Yes.
And therefore you would rate a trial by the highest court in the land, which is, of course, was the Lords,
Yes.
and still is.
So in just going back to the European experience, maybe the 17th centuries, 18th centuries, the idea was that law did not treat everyone equally. There was a lot of, discrimination against people of lower socioeconomic situations. Is that a fair
Well,
statement?
yes, and even across the channel, the idea of the different estates, and going back to the medieval period, the old
Yes.
saw about medieval period is that there are 3 classes
Yes.
of medieval society: those who worked, those who fought, and those who
Yes,
prayed.
yes.
So it's this idea of everyone has some sort of equal legal status just by virtue of being a human being
Yes.
is very recent idea.
Now, let's talk about the American experience. So we have the idea in Europe, okay, the big dogs get a heads up and they're going to be protected. And then, allegedly, we have our Constitution, we have the American experience within the European American community. I mean, were there protected classes just in that narrow group there? Any
Well,
comments?
it's
in, say,
obviously-
1790.
Yes, well, in America, the obvious differences are African Americans and women to a lesser
Yes,
extent.
yes.
And the interesting thing about the Constitution is that it does not define citizenship. The original Constitution,
Yes.
that is. It just made a bunch of assumptions about who a citizen would be, and then there would be further legal assumptions that all citizens would have certain baseline rights, but none of
Yes.
that was explicitly stated.
So citizenship, just to ask the question, we're in the early part of the foundation of the country. Citizens were, everybody assuming that they're a freeborn European male, I guess they would be called citizens. Were they protected in any way? Were the big dogs against the little dogs? I mean, did we have the Wehrgeld here, anything like that?
No, not really. The only real discriminations you could find would probably be based on property. And a couple of things come to mind there. First of all, that there would almost certainly be property qualifications, real property holding qualifications, in order for a white male to vote. The idea of women voting, the idea of blacks voting, certainly the idea of slaves voting would be outlandish. So property ownership would give you a fuller measure of participation in the political and social system.
Now let's parse out what the word protection means. So if you're a big dog, let's say we're in Georgia, we'll pick the year 1820, you have a big plantation, and whatever happens, you can vote. Maybe many people cannot vote. And so the legislature is going to, if I can say it this way, protect your interest, as opposed to, even though it's not so clearly spelled out, they're going to maybe keep property taxes lower. Maybe they'll, if you get into a run-in with someone at the jury trial, only voters can be there.
Right.
Is that a fair?
Yes, pretty much. That you're going to be judged by a jury of white men, and it's not so much that you will have special protections because you are a white male, but that the incidents that are typical of being a white male, large-scale property ownership, will tend to be protected more in the Constitution or in the state or local laws. And one example that some people have found in the federal Constitution is the Contracts Clause that said states cannot restrict or pass laws affecting the obligation of contracts. So the idea, if you're a man of means, if you're a merchant, if you're dealing, then you are going to be protected from interference in your business affairs by the state government, by the federal Constitution.
Well, now, just to take that a step further, so presumably if you purchased a slave contractually in the contracts, this person was treated as property, then was it construed by the courts that this clause in the Constitution protected your access to your property and other human being? Is that?
Yes. So, for instance, if the state tried to say, okay, all slaves are free, you might be able to have an argument under the Contract Clause that you're interfering with my contractual rights by which I've gained title to this person.
Yes. Well, so we're getting in, just to sail the ship a little bit, we're getting into complicated issues about what protection is. So even though if protection is not spelled out, and then another class of people is obviously not protected, they're not protected. Maybe just ipso facto, the class that is that doesn't have this impediment is protected. So if you were a slave, there was, or shall we say a woman, maybe there was relative, it's not quite the same though, is it?
There's some
females,
differences.
but let's just take people in a state of servitude.
Yes.
Or they were not protected. The law, any comments about that? Were they?
No,
what kind of protections did a slave have?
None at all. Now, obviously, it would depend theoretically on the jurisdiction. That Georgia could theoretically, as a slave-owning state, allow slaves to be able to learn to read, whereas South Carolina, another state where slave owning is allowed, might not. But generally speaking, the state of slavery, the default condition is you had no rights. There's a very famous North Carolina case in the 1820s, State versus Mann, that's decided by Chief Justice Thomas Ruffin, who is one of the famous pre-war jurists. And he gives a very logical, very clear statement of how the slave can have and must have no rights, and that the power of white persons over that slave must be absolute in order to compel the slave to do what the white man wants him to do.
So really, there was there were protected classes, I guess is where I'm selling the ship here. There were protected classes in Europe, and then even though it was a little bit different, there were also protected classes, particularly in the South, and maybe in states where access to the ballot box was determined by property, which was generally everywhere. Is that correct?
Very much until the 1820s, 1830s, when the big democratic revolution.
We left the ladies alone in our conversation, but the law, it did, could you say that they had, say, a white woman, would they have some degree of, they had impediments, but also special protections? Would that be fair to say?
Well, the big question there would be, is this woman married? If she is a femme sole, as was known in the common law, and an adult woman of marriageable age but is not married,
Yes.
then theoretically she could make her own contracts, enter into her own business
Right,
deals.
right.
She still couldn't vote. She probably couldn't serve on juries, but she would have certain legal entitlements in other regards. As soon as she married, her independent legal existence would cease to exist and be merged into that of her husband,
Yes.
in which case she could not carry on businesses or enter into contracts or any number of other things.
Well, I guess where I'm settling the ship a little bit
Yes.
is the idea of widows and orphans, or the law paying special attention to, let's say, people that they think might need extra protection, and that would
Yes.
be the ladies, if you say
Yes,
it that way.
yes.
And they had the sort of the, I guess, the idea of male nobility, or
Right.
it's a sense of, I guess, responsibility. So in legal issues, the courts would sometimes tilt in the direction of the aggrieved female,
Yes,
and
yes.
the different.
Yes.
They would look out for their interests as they would an orphan. as far
Right,
as-
and if you're talking about a widowed woman, for instance, then in common law she would have dower rights. She would have first shot at the estate of her husband, for instance, in order to provide for her support. So you have that sort of paternal protection.
Okay,
there
well,
as
so
well,
we sailed the ship into this situation. And then the idea arose in the country
Mm-hmm.
about, well, everyone is equal under the law. So we're going to go through must I say, a brief phase where the idea was that we're going to try and get away from protected classes. And then we're
Mm-hmm.
going to treat everyone the same, no matter, every human would be treated the same. Everyone has the right to vote. And it would be the situation that I've maybe made reference to before in France, where the law really pushes hard for equal treatment no matter what, no protected classes that are obvious there.
Right,
So
right.
we had a brief phase of that, did we not?
Yes, and it's really interesting, this process, which actually worked itself out over a bare minimum of 3 or 4 decades, was, if you think about it, taking Jefferson's famous statement in the Declaration of Independence and trying to make it into something more than the propaganda that it
Yes,
was, in
right,
fact.
right.
And that's one way that Lincoln is described, that he actually took this statement that all men are created equal
Right.
seriously.
Yes.
Now, he's not the first.
Right,
You
right.
had you had many people during the democratic movement of the 1820s
Right.
and 30s starting to say that all men are created equal as long as they're white.
Right.
And that had not even been done before the age of Andrew Jackson.
Yes.
And then Lincoln just extended it further and then just said, well, why not all human beings? Why don't
Right,
they all
right.
have at least the equal opportunity to make
Right,
something of
right.
themselves?
So I guess just making the comment, we have this extension of the privilege of voting. There's great efforts underway for equal treatment as best it can be accomplished. And then there was a bit of an overshoot. Is that a fair statement? And now we're back, as we've always been, into protected classes again.
Yes, who have special legal, I'm not sure if I'd use the word entitlements, but certainly
Yes.
special legal consideration. And the idea is that that this consideration is designed to offset the discrimination that is still presumably inherent in society, rather than to give them a leg up. It's designed to level the playing field. But
Yes.
I think I'm hearing that you're going to contend that it's taking a level playing field and
Well, I mean, I'm just
restoring
bouncing
it,
the
so,
basketball
yes.
a little bit about the way that it's, how difficult it is to have equality before the law, and is that good or bad, and where are we, and
Yes.
what's our present situation?
Yes.
So right now, the courts and the legislatures are carving out great numbers of protected classes. And can you talk a little bit about the present situation with protected
Sure, I think
groups
that-
that get special attention?
Yes, I think the constitutional history of it begins right after the Civil War with the passage of the 13th and 14th
Yes,
and 15th
yes,
Amendments. 13th obviously ended slavery. 15th did away with racial discrimination
Yes,
in voting,
yes,
at least
right,
in theory.
right, right.
The big one here is the 14th Amendment.
Yes.
It's the single most important amendment ever passed. And the tail end of Section 1 of that amendment, 14th Amendment, says that no state shall deny to any person within its jurisdiction the equal protection of the laws. And that's really the first great constitutional concession to this concept of equality. And notice that it was aimed at the state governments because the idea that everybody had in mind was slavery,
Right.
and slavery was a state institution.
Now, did it mean the federal government could not afford, it would be just the states were doing this? And
Yes.
then maybe the feds could continue to act in a discriminatory fashion?
Yes, exactly.
They could deny equal protection.
Right,
but not
just
the
as
states.
just as the first 10 amendments were aimed at the federal government,
Right.
because in the 1780s we remembered England and we
Right,
didn't trust
right,
the
right,
feds. In the 1860s, the nation didn't trust the states because it was the state governments that had seceded from the Union and fought for slavery.
Right.
So the Equal Protection Clause was there. It largely lay dormant for nearly 100 years.
Right.
And then you really saw the big upswing come with the Brown versus Board of Education
Yes.
case in the 1950s that said
Right.
separate schooling is by
Right.
its very nature unequal.
Right, right. Now, just to keep talking about it, that's quite a thing that was put in, I think, 1868, around then. That's about
Yes.
right on that. I think I got the right year. But the takeaway message is that this particular part of the Constitution should stop the idea of protected classes. To me, a layperson reading this constitutional amendment would say, well, that means we can't have protected classes. But it appears they've started to arise in tremendous fashion now. Is that right?
Yes, and I think the first big affair or big event when that came to the public eye that equal protection may in fact lead to unequal treatment or protected classes was the concept of reverse discrimination, which was
Yes.
a very big item in the 1970s.
Right, right.
The big case there was Bakke versus Board of Regents,
Right.
when Alan Bakke tried to get into, I think, the University of California Medical School,
right.
and he asserted that he had been denied admission strictly because of his
right,
race, strictly
right,
because
right.
he was white.
Right.
And the court divided on that issue and gave a kind of muddled
Right.
answer, saying essentially that race can be taken into account in admission decisions to offset the history of racial preferences
Right,
in favor of
right,
rights,
right.
but it couldn't be the determining factor.
Yes.
It couldn't be, we're going to take this person because he's black, we're going to turn this person down
right,
because she's
right,
white.
Right. Now, what we're doing is, as we could go through the different ways that over the past, several decades, all kinds of laws and different kinds of legal opinions have fashioned out great numbers of Americans for special protection and special advantages. And now the Supreme Court is getting ready to actually enter into this complicated discussion because it does appear that there is at least the Constitution makes it hard to justify protected classes. It's very tough, but it appears that they're in existence. And now I think this is with the Voting Rights Act. There are some efforts underway and other issues too, about how people are going to be protected and receive special treatment. And the court's getting ready to opine on that soon, are they not?
Yes, and the court's done that for many years. I think the two big clauses in the Constitution that the court has looked at and then has been acted upon are the Equal Protection Clause,
Right.
which since the 1960s
Right.
has been extended to the federal government.
Yes.
And the interstate
But not by the Constitution, just by
by
the
court
courts.
action. By court action.
So the courts, just as we've talked before, because it's so hard to revise the Constitution, the courts are constantly changing the Constitution, more or
Yes,
less.
yes.
They just change it as they wish, and that's where we are on the subject.
I think I would not go quite that far, but I think there is a big element of what the judge had for breakfast.
Yes.
So the whole idea of critical legal studies, which began as a radical left-wing, almost
Yes,
Marxist
right.
philosophy, was that there is no such thing as law. There is what
Right.
judges want,
Right,
and they try to make it look dignified and legal.
Well, here's our situation. So the courts, in their wisdom, thought, well,
Yes.
the country needs to rectify these past wrongs. We're going to give some groups of people special protection. And even though this more or less violates the spirit of the Constitution, we're going to let it sit there. And then the courts are going to maybe make some decision to change it, or what do you think? Any comments? How does that decision appear to be shaping up?
Well, it's hard to tell. once again, Kennedy is the swing vote. It depends, and the what he had for breakfast really
Yes,
is a big
yes,
deal because actually in the big case where everyone was looking at Kennedy
Right,
last
right,
summer,
right,
the
right.
Obamacare case, Kennedy voted to say that no, this is
Right.
not good in interstate commerce. It was Roberts. It was a conservative who
Right,
voted.
right,
So
right.
so Kennedy holds a great deal of power in his hands in this decision.
Yes,
and
yes.
and nobody has ever really been able to predict very well how he was going to come down on it.
Now, just to keep talking about it, the whole notion to me of protected classes, there's some problems with that for the long-term sort of tranquility of the country, because firstly, I think it promotes substantial economic inefficiency. So if they're constant, rather than finding the best, assuming everybody has an equal chance, finding the best person for the job, there are different kinds of expenses and different kinds of legal complications
Yes.
with the way the country's working and the burden that are imposed by the notion of protected classes has a distinct decrease, if you could say this, in the national GNP, the competibility of the country, the national power. I mean, there's some problems, and it's an enormously expensive thing to have.
Yes, and a good example of that is the Richmond versus J.A. Crosland case of 10 or 15 years ago, which was another affirmative action case. And if I'm remembering correctly, the facts of that case was a Virginia law regarding the hiring of contractors to build
Right,
buildings and
right,
such.
right.
And could there or must there be racial preferences given to minority-owned businesses?
Right, right.
And the other flip side of that is, if the answer is yes, then there's interference in freedom of contract.
Yes.
The one thing that I would warn you about is that that the Constitution is not designed for maximum efficiency. So I think that has been a justification for the interference with the free market, for instance. That it's not all about efficiency; it's about fairness. Although the word fairness, of course, does not
Yes,
appear
yes.
anywhere in the Constitution,
Right.
the equitable idea.
And I think
So,
you've actually touched
yes.
a rather important comment. We've mentioned it before as we discussed health care, is the idea that the Constitution is not there to promote efficiency, but
Yes.
rather, you could say, preserve liberty, and you could say, make an effort at righting past wrongs with the notion of this notion of fairness. However, it gets to be, it's a very slippery slope, isn't
Well, it's
it?
fraught with trouble, yeah.
Once the law and the country recognizes protected classes, the concept, that's okay. It's just fine to have protected classes.
Yes.
That inevitably causes mistrust and tension, and it's pretty, in the long term, I would submit, fairly destructive. And do you think the courts are going to recognize that? And I keep hitting that subject again.
Well,
here.
it's hard to tell. I mean, I think the whole basis for, and we'll stay with affirmative action as a model
Yes,
for
yes,
this because
right.
it's a good model, I think, is that it is designed to remedy past evils, to remedy
Yes,
past
right,
discrimination. The black community is still the lowest income. It's still the most impoverished.
right.
So there is a rationale for that, but the problem with that is, how long does it last? At what point can we say the past problems have been corrected? At what
Right.
point do our generations create their own problems?
But you could also make the case
so-
that an immigrant coming to the country
Yes.
sort of even though he's had no experience, nothing, comes in and then falls under the rubric of a
Yes.
protected class.
Yes.
So one of the things going on with the country with this notion of protected classes is immigrants, to their great surprise and sometimes joy, discover
Yes.
that once they're in the country that they have special status and special privileges.
Yes.
But the argument that they've or these wrongs have been levied
Yes.
against them by society it hasn't happened to them. They didn't live here, but
Yes.
nevertheless they're getting this benefit.
Well, you can look at the other side of the coin as well. What about the mass wave of post-Civil War immigrants, staying again with the African American
Yes,
issue,
right.
who not only did not own slaves, they never had the opportunity to own slaves. They were not part of the system that countenanced the
Right,
owning of
right,
slaves,
right,
and yet that they might be disadvantaged based on.
You mean people who live
based
in
on-
eastern Tennessee or mountain people? Is that what you mean?
Well, I'm thinking of the Eastern and Central European immigrants
they came later.
that
Yes,
came in
yes.
after
Just the point,
emancipation.
right? So
Yes,
it's a bit of a shock to somebody from Lithuania that
Yes.
arrives and discovers the law has some kind of discrimination against him. That's a rather slippery slope, isn't
Yes.
it? These notions of discrimination. Now, What about the situation with veterans' preference? I mean, that's you could say that there's another protected class or people that get some kind of extra,
Yes.
I guess, lift up from the
Yes.
system. Is there a difference between that kind of protected class? I mean,
Well, I
presumably
would
you have
s-
to earn it, presumably.
Yes, I would say that exactly, that it's not some sort of inherent characteristic. It's something that, if you will, it's almost contracted for.
Yes.
If you look at the GI Bill, for instance.
Right.
And if you look at the GI Bill in light of World War II,
Yes, sure,
I think
sure.
no one would have begrudged the veterans
course,
of World
you know,
War II
right,
anything.
right, sure.
So I think that's a major difference in that it's almost a contractual kind of thing. Not quite, but more of a reward for services rendered,
Yes,
if you will.
yes.
As opposed to an inherent characteristic that can't be eradicated, that's obvious to a potential employer, of that sort of thing.
Yes.
So,
Well, you know, if you look into the whole whole issue of I guess it's the particular against the general. So you have if you have a case or any kind of conflict that's taking place, there
Yes.
might be say some kind of legal dispute, the facts of the individual
Yes.
case, and the courts tend to lump these cases together sometimes based on these protected classes, and then reverse legal opinions just based on the fact the protected class might have been harmed in some way.
yes, and it has to be statistical or general, because yeah, that's where the original problem of inequality began. It began with stereotypes.
Yes, yes.
And therefore the remedy seems to be in applying stereotypes as well. Now, the downside of that is, of course, two wrongs don't make a right.
Yes,
and
yes.
the open-ended nature, you know, when it's almost like the
right.
war on terror.
Right.
Are we ever going to be able to say, the war on terror is over, we've won?
Yes,
we can't.
We're going to have
So,
a big discussion about
Yes.
that another sitting here.
Yes.
But, you know, the takeaway message is it seems pretty complicated about how to make our country work. We have over 300 million people, and we have these special categories that we're constantly trying to adjust and maneuver around.
Yes.
It's really having a terrible impact. I mean, you know, I'll just talk about that. I mean, one other group we haven't spoken about, I guess they're, you know, I don't quite understand all the nuances of this, but there's a protection of, I guess, women. They have special protection of the law, and along with that, people of different sexual orientation are getting a special protected class carve-out.
Yes.
Is that a fair
Well,
statement?
the big federal law categories, which is based not so much on the Equal Protection Clause as on Congress's use of the interstate commerce power, the ones that you see often named, and you'll see a lot of them named in the Civil Rights Act of '64,
Yes.
would be race, national origin, ethnicity. Those are the big ones.
Right.
You have other acts dealing with age discrimination, equal pay for equal work. You have the Americans with Disabilities Act, which deals with people with disabilities.
Yes.
Those are the big ones. Sexual orientation, that has so far really come from the courts and not from legislatures.
Yes.
In most places where same-sex marriage has been put to the voters, most states
Right,
have
right.
said no.
Right.
It's been done by judicial action.
Right.
So, so the question is where that's going to go. But I am personally not aware of anything, certainly in federal law, that makes sexual orientation one of the protected classes. But it's coming in through the courts.
You know, I think there's some. Well, I imagine that the ship is sailing in that direction.
It seems like it is.
And you know, we just have to, I guess, constantly assess these issues to see if that's the right thing for the country. And that's a daunting task often, isn't it?
Yeah, because there's a fundamental tension there. You have the liberty clauses in the 5th and 14th Amendment due process clauses, which deal with liberty of property and personal
Yes,
liberties.
yes.
And how does that work with equality? You know, I've always thought that the Rousseauian, I don't know if Rousseauian is a word, but the Rousseau's cry of liberté, égalité, fraternité
Right.
has an internal in contradiction built into
Yes.
it. If we're all free, how can we all be equal? Because freedom implies the freedom to be unequal
Yes.
in a good way. I have the freedom to be richer than somebody
Right,
else or smarter
right,
than
right,
someone
right,
else.
right.
So,
Well, on that note, Vic, Bucky, we'll continue our conversation another time. Thank you
Look
so
forward
much
to
for
it.
coming.
Thank
It was
you.
a very, very enlightening interchange.
thank you.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.